Hello, my name is Takdir, and I'll be talking about prisons and prisoners' rights in early Canada. I'll be looking at some historical milestones, locations, and events that took place which paved the way for prisoners' rights in the present day. In early Canada, criminal justice systems were heavily influenced by British traditions, which prioritize retribution and deterrence, like in common law. These sentences would include things like public executions, flogging, which is a punishment in which victims are repeatedly whipped with a stick, and incarceration in harsh conditions, like solitary confinement. In 1894, Kingston Penitentiary was opened, its first isolation unit, often referred to as simply as Kingston Pen. It is one of Canada's most famous and historical prisons, located in Kingston, Ontario. It is operational for nearly 100 years, 180 years I might say, before its closure in 2013. Policymakers believed that solitary confinement was a good disciplinary mechanism. It was designed to reform criminals through a strict regimen of labor, silence, and religious instruction. When I say strict regimen of labor, I mean such things as quarrying limestone, making furniture, and other industrial tasks. This was believed to be a method in which prisoners would be instilled discipline. Today, it serves as a stark reminder for Canada's justice system, early struggles, and ongoing reform. When we look at the next slide, we can look at another courthouse. In the early 1800s, prisons were essentially jails attached to courthouses. They were used for holding debtors for civil process, and to a lesser extent, for holding accused persons who were waiting for trial. This is Annapolis County Courthouse. It was constructed in 1837, and it was later enlarged. It is one of the oldest courthouses in Canada, and fun fact, it is still in original use. Now, when I look into religious instruction in early Canada, reformers were mostly of Christian background. They viewed crime as a moral failing. They believed prisoners needed to be corrected spiritually. Because of this, prisoners were forced to participate in daily prayers, Bible readings, and even sermons as daily routines. A lot of criticism came from these priorities because they undermined the addressing of inmates' deeper psychological issues and forced them to participate in religion they knew nothing about. Next, let's talk about the evolution. Probation is one of the big things I want to talk about here. The first legislation for parole was brought in 1899 by Wilfrid Laurier, the Prime Minister. He called it the Ticket of Leave Act. It was then fleshed out as the Parole Act in 1959. Its purpose was the gradual integration of prisoners into society. It also helped prisons have good behavior from their prisoners as they served their sentence. This parole reflected a shift in the correctional philosophy towards rehabilitation, which emphasized support and oversight rather than overextended incarceration. By the mid-20th century, Canada's justice system had largely transitioned to a hybrid model that sought to balance punitive measures with rehabilitative efforts. This was good news for the prisoners, as they no longer are forced to have religious instruction forced on them, daily harsh labor enforced onto them. However, there are still tensions between these goals persisting to this day, and this is what my partner will talk about next.
Current legal rights and challenges in the system. Canada's legal landscape, particularly with regard to human rights, has evolved significantly over the past several decades. Much of this transformation can be attributed to the Charter of Rights and Freedoms, which was enshrined in the Canadian Constitution in 1982. The Charter seeks to uphold fundamental rights, but challenges persist in areas, especially when it comes to the rights of prisoners. Key legal cases have shaped the current landscape, but persistent issues still highlight the need for reform to ensure fairness and justice for all individuals, especially marginalized and vulnerable populations. Some of the issues that prisoners face, such as voting, healthcare, legal representation, among others, such as mental health issues, solitary confinement, and overcrowding, are what we're going to cover today. The development of human rights law and the Charter of Rights and Freedoms. Before we get into this, we have to understand how and why certain things are the way they are, like laws and rights. So before the Charter, Canadian rights were primarily protected by laws like the Canadian Bill of Rights, a federal statute in the common law system. However, the Bill of Rights was not constitutionally entrenched, meaning that it could be changed by the Parliament, which limited its effectiveness in protecting individual rights against government overreach. The creation of the Canadian Charter of Rights and Freedoms as part of the Constitution Act of 1982 marked a significant turning point. The Charter entrenched a wide range of civil liberties and rights within Canada's Constitution, making it much more difficult for governments to infringe upon them. Section 1 of the Charter allowed certain rights to be reasonably limited, but this provision set the stage for many of the legal challenges that have followed. It's through the courts that many important legal precedents regarding human rights have been established, including cases addressing things like voting rights, healthcare, and legal representation. The first section we're going to cover today are voting rights. Voting rights are a cornerstone of democratic participation. It's what makes a democracy, and I think everybody would agree on that. The Saw versus Canada ruling of 2002 affirmed that the right to vote is fundamental, even for incarcerated individuals. However, prisoner disenfranchisement still remains a challenge to this day, where prisoners' rights to vote may be restricted depending on the length of their sentence or other factors. In the 2002 case of Saw versus Canada, the Supreme Court dealt with the issue of prisoners' voting rights. At that time period, prisoners or inmates could not vote in any federal election if they had a sentence of 2 years or more. An inmate by the name of George Sauve challenged this law, arguing that it would violate his right to vote under Section 3 of the Canadian Charter of Rights and Freedoms, which does guarantee every Canadian citizen the right to vote in federal elections. The court eventually ruled that the blanket disenfranchisement of prisoners did violate Section 3 of the Charter, and this decision was rooted in the principle that voting is a fundamental right that should not be denied arbitrarily. This ruling was significant in affirming that prisoners have a right to participate in democratic processes, though it only applied to federal elections, not provincial or municipal ones. The federal government then, in 2006, introduced a bill called Bill C-17, and it was passed in 2007, that prohibited prisoners serving sentences of 2 years or more from voting in federal elections, essentially reversing the Supreme Court's decision. The ongoing impact is that prisoner disenfranchisement laws are still contentious, with debates ongoing about whether criminals, especially those convicted of violent offenses, should have the right to vote. Some advocates argue that disenfranchisement further marginalizes already marginalized populations, while others believe it is a natural consequence of losing certain rights as part of the punishment. Prisoners can still not vote in municipal elections. There are a lot of legislatures that put certain conditions which restrict them from voting. They still can't vote in provincial elections if they're serving more than 2 years. And to this day, prisoners serving more than 2 years cannot participate in a federal election. Healthcare rights. In Canada, healthcare is a fundamental right guaranteed under Section 7 of the Charter, which covers life, liberty, and security of the person. However, healthcare within the correctional system is often inadequate, especially for individuals with mental health or chronic health conditions. Some of the current challenges are that a large portion of individuals incarcerated in Canada do suffer from mental health conditions, including depression, anxiety, and even more severe disorders like schizophrenia. However, prisons still often lack sufficient mental health professionals or treatment programs. The system is ill-equipped to address the complex needs of these individuals, potentially leading to self-harm and leading to worsening conditions. The access to medical health care isn't also great. Healthcare delivery in prisons can be subpar, with long wait times for medical attention, inadequate treatment for physical conditions, and insufficient care for chronic illnesses. This results in prisoner rights being compromised under the Charter. Another issue that incarcerated individuals face is access to legal representation. Section 10b of the Charter ensures the right to legal counsel upon arrest. This guarantees that individuals who are detained or arrested can consult a lawyer without delay. The thing is, though, access to legal aid is still often insufficient, especially for low-income or marginalized populations. In provincial systems, there are sometimes long delays in securing legal representation, which can lead to violations of fair trial rights. Indigenous and racialized communities also face particular challenges in accessing competent legal representation, which can contribute to disproportionate convictions and sentencing disparities. Now we will cover some of the ongoing challenges in the Canadian justice system. We did talk about this a little bit before, and it is part of healthcare rights, but again, we're going to emphasize this more. Mental health issues are prevalent in Canadian prisons. The prison system often serves as a catch-all for individuals with mental health conditions rather than providing appropriate treatment for care. This could be solved by having more penitentiaries that could provide better care to the incarcerated with mental health conditions. These conditions can also be exacerbated by overcrowding, limited resources, and inadequate mental health training for the correctional staff. The Supreme Court of Canada has also ruled in several cases, such as R.V. Brown of 2019, that prolonged solitary confinement and inadequate mental health care can violate the Charter. However, mental health care in prisons still remain a significant challenge, with calls for more comprehensive reform. Solitary confinement. If we're being honest, I don't think I could do solitary confinement. I don't think you guys would do well either if you guys were in solitary confinement. But this is a reality that a lot of people in these systems do face. The use of solitary confinement, especially indefinite or prolonged solitary confinement, continues to be a critical issue in Canada. In 2019, the Canadian government passed Bill C-83, which imposed limits on the use of solitary confinement, particularly for those with mental health conditions. The use of solitary confinement has been criticized for its psychological harm, particularly for individuals with pre-existing mental health conditions. The United Nations has also called solitary confinement for more than 14 days, quote, a form of torture. Despite legal reforms, solitary confinement remains in practice, particularly for high-risk individuals or those who are deemed a threat to others, raising ongoing human rights concerns. Overcrowding, the complete opposite of solitary confinement. Overcrowding in Canadian prisons has been a long-standing issue, leading to unsafe living conditions, increased violence, and a lack of access to resources, causing almost what I would like to say like a fight for resources. As of recent reports, prisons across Canada are all operating above capacity, especially in maximum security facilities. Overcrowded conditions can lead to violations of the Charter, particularly regarding living conditions and prisoner safety. The Supreme Court of Canada in R. v. Simpson of 2005 held that overcrowding could infringe upon an individual's right to life, liberty, and security. Overcrowding is also linked to systemic issues in the criminal justice system, including over-incarceration, particularly of indigenous and black individuals, and this calls for alternative sentencing, like community-based sentencing, restorative justice, and expanded parole programs, which are some of the key reforms being advocated. So, what now? Canada's criminal justice system has made significant strides in protecting the rights of individuals, particularly in landmark cases such as Saw versus Canada, which we covered a little while ago. However, there are ongoing challenges that continue to undermine the effective realization of these rights, particularly in the context of physical mental health care rights, living standards rights, and prisoner disenfranchisement. Legal reforms are needed to address these systemic issues, ensuring that the justice system is not only fair, but also humane, all while being aligned with constitutional guarantees of rights and freedoms. Basically, it needs to uphold the Charter of Rights and Freedoms. In conclusion, we still have a long way to go.
Hi, my name's Luke, and today I'll be highlighting how organizations, reforms, and debates have helped shape the journey towards justice in Canadian prisons. The role of advocacy groups in promoting prisoners' rights. Advocacy groups have played a pivotal role in advancing prisoners' rights in Canada. One of the most prominent organizations is the John Howard Society, which was founded in 1866, named after a British prison reformer. The society initially focused on improving prison conditions and ensuring humane treatment. Today, it supports rehabilitation, reintegration, and public education, advocating for alternatives to incarceration. Another key player is the Elizabeth Fry Society, which focuses specifically on the needs of incarcerated women. Founded in 1939, it works to address systemic inequities in how women are treated in the justice system. Issues like domestic violence and poverty often contribute to the criminalization of women, and the society seeks reforms to account for these factors. Advocacy efforts have also been instrumental in raising awareness about the negative impacts of solitary confinement. Groups like the Canadian Civil Liberties Association have campaigned against prolonged isolation, citing studies that link it to severe mental health deterioration. Their advocacy contributed to a landmark decision in the Canadian Civil Liberties Association v. Canada in 2019, which ruled prolonged solitary confinement as unconstitutional. Another example is that the CCLA played a role in reducing the use of segregation in Canadian prisons. Their efforts highlight how solitary confinement disproportionately impacts vulnerable populations, including Indigenous and mentally ill prisoners. Recent reforms in prisoner conditions and rehabilitation programs. Recent decades have seen significant reforms aimed at improving conditions and emphasizing rehabilitation. The closing of the Kingston Penitentiary in 2013. Opened in 1835, Kingston Penitentiary was notorious for its overcrowding, abuse, and lack of rehabilitation programs. Its closure marked a symbolic step towards modernizing the prison system. Federal mental health strategy. Recognizing the prevalence of mental illness among prisoners, the Correctional Service of Canada introduced a mental health strategy focusing on timely diagnosis and access to treatment in 2019. Indigenous programs. Acknowledging overrepresentation of Indigenous people in prisons, culturally sensitive programs like healing lodges have been introduced. These lodges incorporate Indigenous traditions and community support to aid rehabilitation. Ongoing debates. Despite these efforts, a lot of challenges still persist. Advocate groups argue that current rehabilitation programs are underfunded, and debates around mandatory minimum sentences continue. As critics claim, they contribute to over-incarceration and disproportionately affect marginalized groups. An example of this is the case of Ashley Smith, a young woman who died in federal custody, which highlights the need for systemic reform. Her death, after being subjected to excessive solitary confinement, led to widespread calls for better mental health resources and oversight in prisons. Future directions in prisoners' rights. The future of prisoners' rights in Canada depends on addressing the unresolved challenges and building upon recent successes. Restorative justice initiatives, which involve the victims, offenders, and communities in addressing harm, are gaining traction, and studies show that they can reduce reoffending and promote healing. Overcrowding also remains a major issue. Advocacy groups propose solutions such as alternative sentencing for non-violent offenders and expanding community-based correctional programs. Also, incorporating technology to improve access to education and vocational training for inmates is a growing area of interest. These tools can help equip inmates with the skills to reintegrate into society effectively. Advocates also call for independent oversight bodies to ensure accountability in correctional institutions. This includes monitoring the use of force, solitary confinement, and access to health care. An example is in 2021, the Office of Correctional Investigators recommended creating a prison ombudsman to act as an independent advocate for prisoners' rights. This proposal aligns with the international best practices and could bring greater transparency to Canada's correctional system. Overall, the evolution of prisoners' rights in Canada is a testament to the power of advocacy, the necessity for reform, and the importance of future innovation. Groups like the John Howard Society and the CCLA remind us that progress is often driven by those who stand up for the marginalized. As we look forward, the goal must be to balance the justice system with humanity and ensuring that every person, regardless of their circumstances, is treated with dignity. Thank you.